highly respected and high profile practice in corporate and white collar crime. So this fits perfectly in his sweet spot. I'm going to say a little bit about housekeeping. While Patrick's speaking, please make sure that your microphones and your cameras are off. And also we are going to be recording this session. So without further ado, over to you, Patrick, and thank you again.
Pleasure, and thank you very much for those kind words of introduction, Gaynor. I'll try to do nothing to make the audience feel that they're completely unwarranted. But no, today's session is on changes to corporate criminal liability in the UK, and in particular looking at the recent changes under the Economic Crime and Corporate Transparency Act. We've got a bunch of slides in relation to these. I'll try and rattle through them. There is a chat box here, so if anybody does have questions, I'll probably pause at the end of each section. Essentially, if we flip on to the next slide, there's sort of 4 areas which I'll be looking at, which is the sort of introduction as to why changes were needed in the first place. So again, if anybody's got any comments in relation to that, feel free to stick in questions in relation to the chat box when I'm going through that. The next area is really why that needed to be sort of expanded and how that expansion has come about. The third area will be looking at failure to prevent fraud, which is one of the sort of major changes which has come about. And then the sort of final area that we'll be looking at is how companies can really protect themselves and what things that they should put into place to do so. So I'll pause at the end of each of those sections, and then potentially we can open up to the audience for questions in relation to that, because at least then questions are based on the sections that I have gone through. So just checking with Sandra if you're able to move it on just to that agenda section, and from there, if we're able to move it on to the page number 4 as to the general sort of introduction side of things. Excellent. Okay, so that's the the agenda section. So I've mentioned sort of 4 areas that I was planning to go through. But if we can move on from now to sort of page number 4, which is the kind of reason as to why there is such a focus on corporate crime and financial crime globally. What we are be looking at in slide 4 really is the Corruption Perceptions Index 2023, which is a thing which is researched each year by Transparency International. And what they effectively look at is perceptions in each of the countries across the world, and how people view the public sector and its propensity to be bribed within those jurisdictions. And you can see there from the heat map, when it eventually comes up on the screen, you can see it in tiny version on the left-hand side of the screen, but the main slide hasn't, due to obviously technical issues, hasn't opened up there. You will see that most of the world is effectively darker shades of red, which means it's more likely to be viewed as corrupt, whilst those areas which are yellowy, orange are less likely to be viewed as corrupt. And frankly, you will see that the one of the few areas which is viewed as not being corrupt is the Arctic and the Antarctic. So the rest of the world is prone to be viewed as having significant corruption issues, and annually the cost to the global economy of corruption is $2.6 trillion, which is significant. And also in terms of the UK, it's anticipated or estimated that around 100 billion sterling of dirty money passes through the UK every single year. So as a result, it's a significant issue globally and a significant issue in terms of the UK. The next slide, I'm not sure, Sandra, if we're able to flip over to slide number 5, is a slide which looks at global enforcement hotspots.
Sorry, I'm having
and
trouble with PowerPoint at the moment. It's just not responding. So I don't know if you can do any better your end with it. I've just got nothing going on here.
Okay, well, let me just pause a second. I'll just put myself on mute and see if I can do a screen share. Bear with us, everybody, while we have a little technical glitch. I'm not sure what people can see now. Is there anything up on screen?
There is, Patrick. It's back to slide 1.
Slide 1, fantastic. I think these may well be my slides. And is that now slide 2, the agenda one?
Yes, yeah.
Fantastic. Okay, well, I've lost the ability to see myself and the audience, but there you will see the corruption perceptions index, which is the one I've been talking about. And moving on from there, this is the enforcement hotspots, and you see again the darker areas are the jurisdictions which are named and shamed effectively as being areas where enforcement of against public officials in those jurisdictions have been quite high. And an interesting recent report, the Home Office Economic Crime Survey, interestingly found that 20% of UK businesses have experienced or been victims of fraud, which is an interesting statistic because, again, another recent statistic showed that 40% of all fraud, or of all crimes within the UK, was fraud related. So that the Home Office one here of 20% of businesses being affected, being 20%, seems to be likely an underestimate. And curiously, hitherto, approximately only 1% of UK law enforcement resource has been focused on fraud. So the government has essentially introduced a new strategy in relation to dealing with fraud and economic crime, which is has raised it significantly up the agenda to stop London being viewed as Londongrad, or a centre where monies can be laundered with relative ease through the property market. And also looking at how companies can be held more responsible for the activities of their employees. So that really is the rationale behind the changes which have been brought in underneath the Economic Crime and Corporate Transparency Act 2023, which Nick F. Grabe, the new director of the Serious Fraud Office, my former employer, has stated that it's the most significant boost to the SFO's ability to investigate and prosecute serious economic crime in over 10 years. Actually, I think that significantly understates the changes. I think this is the biggest change to corporate crime in well over a century. It's absolutely staggering how broad these changes are, and actually the level of understanding of how much this impacts businesses is frankly not widely enough known. In terms of the other positions and the other powers that have been brought in, these are outlined in slides 7 and 8. I'm not proposing to go through them here because there's a number of other changes, but the two most significant ones are really the expansion of the identification principle and also the introduction of a failure to prevent fraud offence. And really the reason behind that is how companies were able to be prosecuted prior to the introduction of this legislation, which is, can you identify the directing mind and will of a company? And that was a very narrowly interpreted, and as a result meant that it was very difficult for law enforcement to take action against companies at all. The old test is really laid down in two main cases. If one is a keen student of the law, the first one is the Tesco and Natras case. And effectively, that was action taken against Tesco on the basis of the activities of a senior manager within Tesco's. And the court essentially ruled that the directing mind and will of the company didn't expand to senior managers. It was really left with the person, the individual, or the individuals that really were the brains, the eyes and the brains and the sort of central nervous system of a company. And it was really not specifically stated as to who that would be, but the House of Lords generally give 5 different opinions from the 5 judges that were looking at it. But essentially, the general view was that it was the board of the company. So you needed to have board knowledge. And the SFO and Barclays case was one where that's essentially what the SFO were arguing in that case, that it was knowledge of the board or knowledge of significant people on the board, such as the CFO, Chris Lucas in the Barclays case, or John Varley, who was the CEO, would be sufficient. So sufficient if one person on the board was involved in the criminality. But the High Court in the Barclays case decided actually that it needed to be the ultimate decision maker and only the ultimate decision maker that could make the company liable. So as a result, what needed to be shown in that case was that as power had been delegated to a finance subcommittee, and that subcommittee was made up of 2 individuals, the CEO and the chairperson, both of them needed to have criminal knowledge before the bank could be made liable for it, because they were the 2 ultimate decision makers. But ultimately, there wasn't evidence against the chairperson at all, and he was not being charged. So as a result, Barclays, couldn't be prosecuted in relation to the case, and the SFO, the case was dropped against the bank, and they did not continue against them. The feeling was that this was an incredibly narrow view of Tesco and Natras, and the judge in the High Court in the Barclays case stated that if change was going to be made, it couldn't be done through the courts. It would have to be via legislation. So scroll forward a number of years later, and that's why this legislation was brought into force. So how does this make things different from what was done previously? Well, what has now been brought in is effectively a senior manager test, which is effectively taken from the Corporate Manslaughter and Corporate Homicide Act 2007, which instead of relying upon Tesco and Natras or Barclays to define what who the directing mind and will of the company is, what this new section 196 of ECTA in fact says is that somebody who is a senior manager within the company, if they commit a criminal offence, in particular a financial crime or economic crime related offence, that can make the company liable. So what, therefore, does that mean? Which offences are covered? You'll see here in terms of this slide, number 12, that there's a broad range of offences: theft, fraud, tax, bribery, money laundering, and some other Terrorism Act offences. Who does it apply to? Who is defined as a senior manager? Well, it's defined as individuals who play a significant role in the making of decisions about how a whole or a substantial part of the body corporate's activities are carried out and managed and organised, or the actual managing and organising of those activities. So well, what does that mean, really? It's a bit of a convoluted set of words and phrases. What it effectively means is that people who are decision makers or people who are executing significant parts of the business of the company, who are in hold senior positions, are likely to be viewed as senior managers. And as such, this goes well beyond the CEO or CFO. It goes well beyond the board. It will go to others who have, significant dealings with, say, European activities, or significant dealings with, African activities, or the US and elsewhere. And as a result, this massively expands the potential group of people that can now make a company liable. And interestingly, in terms of geographic scope, even if no act forming part of the relevant offence takes place in the UK, an organisation can still be held liable in relation to it if they would be guilty of the offence in the country in which it was committed. So it looks as if this has got extraterritorial application to a certain extent. This came into force on the 26th of December, Boxing Day last year, and it is something which has largely not made significant headway in the press, which is, frankly, quite staggering, because when one looks at it, if your senior manager or one of your senior managers is involved in committing a fraud, paying a bribe, has knowledge of a bribe or somebody else's bribe taking place and condones it, approves it, etc., the company is now liable for their activities. So again, this is quite a staggering extension of the law from what the previous position was, and is something which has, interestingly, got no defence of. We were training all of our staff. We have adequate systems and controls in place. We have got, rigorous auditing and monitoring. None of that provides a defence in relation to this. This is essentially a strict liability offence. If the senior manager, in the course of their duties or purported duties, commits one of these offences, the company is liable. So this brings us much closer to the American system, whereby if the company makes a benefit and any employee has been involved in some crime which causes that benefit to the company is automatically liable. So what we're moving away from, it's just the very head of the organization that makes a company liable, to senior managers, important people within the organization, will make the company liable. So we're moving much closer to the US position, and this is a significant increase. I'm just going to pause there for a second just to see if there are any questions at this stage in relation to that area before I move on to looking at the failure to prevent fraud side of things. I can't see any questions in the chat box, but if anybody does have any from the audience, feel free to remove your stick up your video and feel free to ask away while I just move the slide on to the failure to prevent fraud side of things.
Hi Patrick, it's Shameen. Quick question. Yes,
sure,
quick question. I'm just curious to understand how this interacts with the SMCR regime in the context of banks, particularly SMFs and MRTs.
Yeah, no, I think that's where it comes from, frankly, because they're looking at the corporate homicide legislation, which is brought in after issues like Zeebrugge and others, where companies were felt should be held liable for kind of health and safety breaches for not putting in sufficient things into place. So as a result, similar language has been adopted from that. But likewise, financial services have had basically regulatory liability for senior managers and for activities effectively conducted by their teams. So that this draws heavily on the regulated sector and brings it across into now a criminal punishment. So I think it's a significant upping of the ante, and it's applying financial services standards effectively across all industries. So these provisions aren't limited to financial services companies. They're effectively completely sector neutral. And that's a significant increase. Unlike the financial services side of things, a senior manager personally will only be liable if they have committed activities which are criminal. unlike the regulatory regime within the financial services sector, a senior manager cannot be held criminally liable for something that happens within that senior manager's team, which they effectively have responsibility for. That remains under the financial services senior manager regime, something which regulatory action can be taken against that senior manager for not effectively supervising well enough, but they can't, under the criminal law, be held criminally liable for that. So I hope that gives you a little view of how the systems kind of interact and are similar and how they are different, but how it pans out in the future is yet to be seen, because this only came into force 4 months ago, 5 months ago, and as a result there's been no actual prosecutions that have been brought under this as yet. But any thoughts from your side, Shameen, as to how you see them interacting?
No, this has been very informative, so I'm now starting to apply my mind to it, to be honest.
Yeah, no, I must admit, I think it's a massive increase. It's an absolutely massive increase in the law. And it's frankly quite staggering, because in many scenarios, what you're doing is you're imposing liability on a company because there's a reason as to why the company should be held liable for the activities of its employees. So as a result, if you're running a ferry across the channel and you forget to close the bow doors, it's one individual that's forgotten to do that, well, frankly, the company should be held liable because it's a significant risk to the members of the public who are there. Whereas this is where an individual could be going out and committing a fraud to benefit largely themselves, and in that case they're holding the company liable for that individual's actions, which is it's a huge increase in terms of the corporate liability. But also, if you don't have in a counterbalance there of a defense for the company doing everything in its powers, you're totally reliant upon prosecutorial discretion to not bring a case, because it wouldn't be fair to bring a case. So how this piece of legislation interacts with the failure to prevent fraud section, which has received a lot more press, I think is going to be an interesting one to compare. Any other questions before I move on to the failure to prevent fraud? I can't see if other hands are up, so if somebody else can let me know if there is any. If there's not, I will move on to the next section.
I can't see any others, Patrick, so.
Okay, fantastic. Thank you. So moving on to the next section. The next section has received a lot more press, largely because it's a lot simpler to understand, which is essentially, if it's section 199, it's a failure to prevent fraud, which is effectively, it borrows the language from the Bribery Act. The Bribery Act brought in a new supervisory type offence of strict liability, was if a company failed to prevent a fraud by an associated person, the company would be strictly liable for that failure to prevent bribery, unless it was able to show on the balance of probabilities that it had adequate procedures in place. So the idea here was that a company had failed to control one of its employees that it had control over, therefore it would be liable, but it would have a defence if it had brought in, as many good procedures as it could to, stop bribery taking place. So that has been seen to be actually a very good way to change behaviours in relation to bribery and corruption. And as a result of that, in 2017, the failure to prevent the facilitation of tax evasion offence was brought in, because again, tax evasion was seen as a bad thing. Companies would have a duty to ensure that people that they were interacting with weren't facilitating tax evasion, and as a result could be held liable in relation to that if they didn't have reasonable procedures in place, changed from adequate procedures to reasonable procedures in place to prevent tax evasion happening. So again, both of those have been seen as successful bits of sort of nudge legislation, because it nudges companies to ensure that they have good procedures in place in order to stop their employees doing bad things, bribery, tax evasion. And because of this focus on fraud, they've decided to effectively wheel out a similar provision in relation to fraud. And basically, it's if it makes a company, a large organization, liable if it fails to prevent an associated person from committing a fraud offence where the associated person intends to benefit directly or indirectly the organization or the person to whom the associated person provides services on behalf of the organization. So again, they've introduced a number of changes which are slightly different from both the Bribery Act and also the facilitation of tax evasion provision under the Criminal Finances Act 2017. They've limited this to large organizations, which again is crazy. Excuse me, when this was going through the House of Lords, Lord Garnier at the time, who I was advising in relation to this bit of legislation, came out with the catchy phrase of, would you ever introduce burglary or anti-burglary legislation, but limited to people that were over 6 foot tall. So as a result, small burglars could happily get away with it. It was only the law only applied to big burglars. And he effectively said it was lunacy to apply this failure to prevent fraud basically to big burglars, big companies, instead of the small burglars, those under 6 foot. And that's essentially what's happening here, because the only companies that will be liable are those that have more than 250 employees, more than 36 million turnover, or more than 18 million in aggregate assets on its balance sheets. The reason why this was thought sensible to bring in by government is really because the Conservative Party, who were bringing this legislation forward, didn't want smaller or more medium-sized enterprises to have the regulatory burden of having to bring in reasonable procedures and the like. So that was the rationale behind it, which then, if you scroll back 5 minutes ago to what I was saying, why on earth is that self-same government introducing liability for every company everywhere in the UK if its senior manager does something criminal? Because that is not just a regulatory burden, it's in fact a massive increase of criminal risk. So the two provisions in terms of imposing burdens on businesses are very different. So the idea behind this failure to prevent was not to increase the regulatory burden, but the other senior manager regime massively increases the criminal burden. So slightly odd that the government wouldn't have thought through the consequences in relation to that. Putting that to one side, the other slightly lunatic thing about applying this only to large companies of a certain size is that large companies are more likely to have reasonable procedures to prevent bribery in place in any event. As a result, they're not likely very much to be prosecuted for it. However, under the senior manager regime, if you're a smaller company and you're prosecuted under the senior manager regime because you can't be prosecuted under the failure to prevent regime because it doesn't apply to you, under the senior manager regime, you don't have a defence of reasonable policies and procedures. So the crazy thing is, not only is the increase in criminal risk under the senior manager offence, that is the only way that you can prosecute smaller or medium-sized enterprises, and also they don't get the benefit of having an available defence because it's absolutely strict liability. So again, the two provisions are completely at odds with each other, and it's slightly insane that that they were brought in such a way. And in fact, Lord Garnier did say, and part of the arguments that we put forward to the Lord Sharp and the Conservative Party who were proposing legislation, was that it makes sense for smaller companies and medium-sized companies to have this defence in place, and it also incentivizes them to bring in better behaviours because they would have a defence if they brought in those policies and those procedures. And as long as those policies and procedures were reasonable and proportionate to the size of the company, if you were a hairdresser on the high street, you would have a significantly less risk of being involved in a fraud or something. So your policies and procedures, with your turnover being so small, could be a lot smaller. And your need and the cost of actually preparing such policies and procedures wouldn't need to be too expensive. But nonetheless, the government decided no, they wouldn't proceed with that. The other thing here is the convoluted definition of what an associated person is. Under the Bribery Act and under the facilitation of the prevention of tax evasion provisions, the definition of an associated person was much simpler. It's basically your employee, your subsidiary, or somebody who provides services for or on your behalf. So much easier to understand. Here, the definition of associated person is in fact significantly broader and significantly more convoluted. So again, that's something, if you're looking at this, is worthwhile to look at in some more detail. In terms of the extraterritoriality of these provisions, it's at this stage unclear precisely how that will be defined, and certainly in terms of looking at what is currently said, it's if somebody commits a fraud under UK law, then, as in the fraud happens within the UK, then the company, whether it's based in the UK or elsewhere, is going to be liable. That's standard territoriality. If a crime happens in the UK, you're liable for it. It doesn't matter whether you're a French citizen that's got the Eurostar popped across here and stabbed somebody. If you stab somebody in the UK, you'll be liable for stabbing them in the UK. So that's just normal territoriality. The interesting bit here is that the government, in the press release in relation to this legislation, said that people who targeted UK victims, or companies that targeted UK victims, would be at risk of prosecution under this legislation, which again is a very interesting one, because the reality is, if you're an overseas company, if you're advertising some kind of investment into, let's say, sort of green plantations in, Indonesia or something like that, and you market that across the globe, but some of that marketing ends up in the hands of people in the UK, none of them, however, invest. The government seems to be saying that that overseas company, with that international marketing, with that targeting of people sort of anywhere across the globe, could be held liable in the UK. I think that's a stunningly wide potential definition, and I think it simply can't be correct in law. I think they've simply misinterpreted it. But again, that seems to be the difference between what they're saying it could be used for and then what the legislation actually says. I won't go through the precise details of what it says within the legislation, because it's thoroughly unclear as to whether or not the activity in place will be liable for conviction within the UK. But certainly what is clear is the fraud offences that when you fail to prevent fraud, the fraud offences are a limited set, which includes fraud by false representation, abuse of position, and failing to disclose information, as well as a number of other offences, such as Section 19 of the Theft Act, and a couple of other sort of financial crime related matters. But it's a much smaller group of offences, specifically fraud and deception related, than the much wider group of offences under the senior manager regime. So again, two slightly different defences available in relation to these offences, and also they apply to different criminal offences as well. So again, a potential minefield in terms of navigating the two of them. Interestingly, under Section 200, the government can increase the number of offences that could make a company liable for failing to prevent fraud, and the Secretary of State can do that by passing secondary legislation, but it specifically states that they need to be offences of dishonesty or similar to the existing offences. And there was some talk as to whether this should apply to money laundering, whether it should apply to sanctions, whether it should apply to other things. It doesn't currently, but it may be extended in the future. Next, So those are specifically detailing there which specific frauds, participating in fraudulent businesses, obtaining services and deception, and so on. So we've sort of gone through that already. So that again just deals, that slide sort of deals again with the kind of dishonest intent sort of required. In terms of the reasonable procedures side of things, two things should be noted at this stage. One, this provision, failure to prevent fraud, hasn't come into force yet. And secondly, what are or what amounts to reasonable procedures hasn't been decided upon yet. So when's it likely to come into force? Likely to come into force after the government has produced guidance in relation to what reasonable procedures amount to. When is that going to take place, or when's it meant to have taken place? It was meant to have come out at the end of Q1, so at the end of March of this year. It hasn't come out as of yet, and there's much negotiating around what should be included within the description of reasonable procedures and within the guidance. The UK Bribery Act guidance took about 18 months to be agreed. I think the Home Office, who is in charge of this guidance, as opposed to the Ministry of Justice, who were in charge of the Bribery Act guidance, are hoping to do it much sooner. But when I last spoke to them a couple of weeks ago, they said it would be coming out imminently. But their definition of imminently is obviously slightly more different from mine. So several months later, they still haven't produced it as of yet. The expectation is that when the reasonable procedures guidance comes out, companies will have a 6-month period to effectively amend their policies and procedures to then have that 6-month window to change things, make it legally compliant before enforcement can take place. Again, 6 months is a crazy short period of time, because what companies will need to do, and we'll look into this in a second in the sort of next section, but what companies will need to do is they will really need to assess their risks. They will need to look at their current policies and procedures. They will need to amend, create, supplant what they've had previously and make them fit for purpose. And then they will need to have sort of monitoring and training and other procedures in place. 6 months is quite a significantly short period of time to be able to do all of that, particularly when this is being applied to sort of pretty large organizations which are going to have potentially global footprints, and as a result this involves a significant amount of work for them to do. Some companies are looking at this already, and we've been involved in sort of advising companies as to what they should be looking at, how they should be preparing themselves and stuff. But what they're really hoping for, and what others such as ourselves are sort of speaking to the Home Office about, is to give a bit more wiggle room, say a 12-month lead-in period. But anyway, one, this isn't in force yet. Two, the guidance is coming out at some stage, hopefully in the not too distant future, and hopefully there will be an extension of time beyond the currently expected 6 months for that to then become then enforceable. But that both of those are things that we're still waiting to see. Another interesting point here is that there's no liability if the company is a victim. Again, the word victim is, and this provision is very unusual. Why on earth has it been brought in? I'm not quite sure as to why it was brought in. I think it's largely as a olive branch to companies to say, well, don't worry, as long as you've got reasonable procedures in place, we're not going to prosecute you. And in fact, also, if you were a victim, we're not going to prosecute you. But the query is, where is is a company a victim? Is it a beneficiary? Is reputational damage enough to make a company a victim, even though it did benefit from the contract itself that was fraudulently obtained? Is the fact that the individual, the employee, the subsidiary, or the agent that was involved with this, even though they were primarily looking to increase bonuses to themselves, so they were intending to benefit themselves, the fact that a contract then went back to the company in question, does that mean that the company was intended to be benefited? Does the fact that the company then gets caught, that this all goes out into the press and it has a reputational hit, does that mean it's a victim? All of these things really aren't defined within the legislation, and in fact what's basically said there doesn't help with what the what view will be taken in the guidance. And certainly in terms of the guidance itself, from what I have seen, it effectively simply says that reputational damage is unlikely to be sufficient to make the company a victim. The version which I've seen of the guidance is not the finalized version, so that remains to be seen how that will eventually pan out. But also it says that victim is not a term of art and is something which should be left up to the court to decide upon. At an earlier stage, it will therefore be up to the prosecution, the investigation teams, police officers, to decide whether or not they view the company as a victim. So those are two live questions. When is there an intention to benefit the company, and when does the company become a victim in these cases? So both of those are areas which I think will be open for different construction. But I think if one is looking to read the tea leaves in relation to this, I think there will be a very narrow view of what makes the company a victim. I think the view will be taken, well, where it's intended to cause specific harm to the company in question by the employee or whomever the associated person is, then the company might be seen as a victim. In terms of whether the company is likely to be seen as a beneficiary, I think we've already got good guidance under the Bribery Act, the Standard Bank case, which took a very broad view, because in that case the primary intention was to benefit a joint venture enterprise in Tanzania, but because monies from that by dividends were being paid up to the UK head office, it was seen as obviously intended that the head office would make some monies out of this, therefore they were an intended beneficiary. So I think we're likely to see a very broad view as to what is meant by the company benefiting, and a very narrow view as to the company being a victim. This again is some more details in terms of an example here as to who might be a victim. I'm not proposing to go through that now. In terms of the extraterritorial effect, I've kind of left this to a little bit later on, because I've read this about 100 times and I'm still not quite sure what exactly it means. So just taking a look at that, a relevant fraud offence may be committed where not all of the underlying criminal conduct takes place in England and Wales. So effectively, that's an assertion that there is an extraterritorial effect. If something happens outside of the UK, it could still be prosecuted within the UK. So this is by virtue of sections 1 and 2 of the Criminal Justice Act 1993, which is the old provision which says that some UK legislation can have extraterritorial impact. So what has when one looks at sections 1 and 2, it's Crown and Smith Wallace Duncan, which effectively says that the criminal law can be applied where a substantial measure of the activities constituting a crime take place in England and Wales, and restrict its application in such circumstances solely in cases where it can be seriously argued in a reasonable view that these activities should. Sorry, I think we just got somebody who's off mute. If they're just able to switch themselves back onto mute, that would be great. So the Smith Wallace Duncan case shows that you can extend territoriality beyond just activities taking place within the UK. And the relevant event test is often what has been applied in the past to the Fraud Act, the Theft Act, and other common law offences, which means that as long as some relevant act doesn't need to be the most important acts, but as long as some relevant act takes place within the UK, then you can have, most of the rest of the stuff happening overseas. So that generally is standard law as to what amounts to sort of territoriality, but this offence is not subject to the irrelevant event test, and it can only be committed in the ways that are outlined within the statute, and that is a very poorly worded section, and is something which I think is going to cause companies very real problems as to when they are likely potentially to be held liable. And certainly when I've been advising companies in relation to this, I've taken a rather sort of expansive view as to what is going to be looked at here, because if one looks at what's appearing on the government press releases in relation to this, simply having an intended UK victim, everything else happening overseas would be sufficient in their eyes. So it shows that they're going to take a very expansive view as to the legislation itself. But when one looks at the wording of the legislation, which I haven't included here because it might send everybody to sleep immediately, but when one takes a look at that, it is very, very convoluted and very difficult to understand, and effectively looks as if what it's saying is if a company would be liable in its own jurisdiction or in the jurisdiction where the event took place, then it could be held liable within the UK. So it's a slightly circular argument and incredibly confusing. But before we move on to sort of practical considerations, I'll just stop there to see if there's any questions from the floor, or whether I have bored people into submission already by dint of going through hard law.
So Patrick, I did have one question. Oh, I do see a hand up. I'll quickly ask mine because it might be quick.
Please.
Is there, just going back a little bit, and I'm sorry if you did say this and I just missed it, but is there a definition of whether a large organisation, as it's defined, includes kind of group entities, or is it kind of one-to-one for a single corporate? So if, for example, a company's got a group in the UK, does that bring the organisation concept? Is that all of that, or is it just the corporate, just the company?
No, it tends to kind of conglomerate them together, and again, this is within the sort of small print of the legislation. So when you read it, you kind of think, well, hey, actually we're only involved in a small UK subsidiary, therefore it doesn't apply to us. But it's a bit like the Modern Slavery Act, because the Modern Slavery Act has got similar provisions in relation to you need to have a turnover of 36 million or something. I think it's the exact same turnover provision in relation to the Modern Slavery Act. But again, when you get into the bowels of that legislation and take a sort of rummage around in relation to it, it becomes clear that actually it's your overall group's activities. So although in fact, and again in my previous law firm, we had X turnover, but actually as a group across the world, we had Y turnover, and the Y turnover was higher than the 36 million. We thought actually the Modern Slavery Act applies to us. We need to get out a Modern Slavery Act statement. So the same way this is likely to be interpreted here. But again, I won't bore you by going through the total provisions, but yeah,
that's helpful.
Yeah, and I think there was
into it myself, but I just wondered if you knew. Yeah, thank you.
And I think there's another hand up from Tarika, if you want to ask the question.
Hi, my question just relates to jurisdiction. You just mentioned that it relates to a similar offence in that particular jurisdiction. Does it require a similar offence in terms of failure to prevent fraud, or does it relate to the underlying fraud?
Underlying fraud, because again, this is a kind of blueprint for disaster, because the reality is, if you're in an utterly corrupt and completely fraudulent jurisdiction of some kind, I'm not saying that there are many of those left around the world, but let's say there was one and it didn't have dual criminality, the reality is everybody would go to said state and happily base themselves there and commit all manner of frauds there. But because they didn't have the corresponding provisions as in under UK law, you could happily get away with that, which seems again completely insane. So it's a very unusual clause. It's very poorly worded, but I'm reading it as similar to the extradition side of things. To be able to extradite somebody in the UK, you need to have the offence which is taking place overseas needs to be an offence which is recognised in law, and there is a similar one within the UK, but it's the underlying offence. It's not the overarching failure to prevent fraud. It's just sort of fraud and economic crimes.
Thank you, really helpful.
No, pleasure. Anybody else have any questions on that before we enter the sort of final furlong?
I don't see any more hands up, Patrick. So.
Excellent. Okay. Well, the next area really is kind of practical considerations, which is really, the kind of main takeaways as to what, us as advisory lawyers, my position, and Sarah's position. I see Sarah George is online as well. For those who operate within law firms will be advising, companies as to what to do and/or what should companies be doing in relation to both of these provisions, senior manager regime and failure to prevent fraud. Well, I think, first of all, in terms of reasonable policies and procedures, you need to operate on the basis that what the government says is true. They are planning to make this come into force 6 months after they hit. They pulled the trigger on the launch of the guidance, and if that guidance comes out soon, in the next couple of weeks or months, it's a 6 month turnaround. So as a result, if you're advising or if you're in a company that has 2 or more of those criterion of 250 employees, 18 million sort of net or 36 million gross sort of turnover, you really need to be looking at this now. And I think what you can do now is you can look at your policies and procedures and decide, do you have a fraud risk assessment there? And in fact, many of those, Shameen's mentioned already, the sort of financial services and the kind of interaction there. Financial services sector since 2011 have had financial crime guidance, which covers about 8 areas of financial crime, one of which relates to fraud, another relates to sanctions, bribery, money laundering, terrorism, and so on. So as a result, financial services companies, I think, are ahead of the game already, because since 2011, they will have had a duty to look at and implement systems and controls in relation to anti-financial crime provisions. So as a result, I think they're in a better position to start looking at this and then updating or reviewing to see their fitness for purpose and updating and amending their policies and procedures. Most guidance, one can take it from government, is likely to be fairly neutral and not likely to be details heavy, and likely to be something which is probably cobbled together from pre-existing guidance. So, I don't think I'm going to be surprising anybody by saying that I don't think there's going to be a significant change in relation to this guidance when it comes out. I think from what I've seen so far and from where I think it's likely to go, I think it's likely to be a little bit weightier than the guidance that we've seen from the Bribery Act and from the failure to prevent the facilitation of tax evasion. But I think it's going to be based around the 6 provisions, which is toned from the top: reasonable policies and procedures, due diligence, risk assessments, training and communication, and then auditing and review. Those are the 6 high-level principles which are applied across Bribery Act, they're applied across financial services, and they're really embedded within a lot of the pre-existing legislation that we have out there. So as a result, you can start looking at these here and now. The next one is obviously just a kind of reporting issue, because again, without getting guidance or needing to read guidance in relation to this, if you as a company or if you as an advisor are able to say to your clients, look, you need to have internal reporting mechanisms so that problems are brought to your attention sooner rather than later. Because the sooner something is brought to your attention, and the sooner it is brought to your attention, as opposed to the regulator or the prosecutor or the investigator, police investigator's attention, the sooner you as a company can get on top of it and deal with it. And as a result, you can then say to the regulator, the investigator, the prosecutor, look, we have these adequate systems and controls, these reasonable systems and controls in place. We also have internal reporting mechanisms. These were brought to our attention. These issues were brought to our attention. We investigated it, we remediated it, and now we're reporting of it. So I think that, again, is something which you can do now, which is look at internal reporting mechanisms to make sure that you have procedures in place. And frankly, they should be already, because the EU whistleblowing directive came out a number of years ago now, so there should be hard baked into most companies procedures in relation to where things can be escalated internally, and a whole process in place in relation to that. So if that's not already been done under the EU whistleblowing directive and so on, it is something which should be and could be looked at now. The next one is really identifying who these pieces of legislation could be applied to, which is who in fact are likely to be your senior managers. You don't need specific guidance in relation to that, because the Home Office is not going to give guidance in relation to the senior manager section. They're only producing and have to produce guidance in relation to the failure to prevent section. So as a result, here and now, this is in force. Companies need to be looking at who their senior managers could be. And the next thing they should also be looking at is who are likely to be their associated persons. So take a look at the definition under the section 199 for the failure to prevent fraud, and see who those could apply to. And as a result, the next step is kind of raising awareness within the company, because it's a defense under the failure to prevent fraud side of things that you've raised awareness, done training, identified your high risk individuals, trained them, etc., etc. And although that's not a defense under the senior manager regime, I think the reality is, if you're able to show to an investigator that you have identified who these people could be, that you have identified who the high risk areas, product lines, individuals, sectors, jurisdictions are, and that you've done bespoke training in relation to them, I think it puts you in the best position to say, please don't prosecute us. Go after the individual, the senior manager, but don't put the company in the crosshairs, because we've pretty much done everything that we do. Those of you who have US practices will know that that's a kind of declination whereby you're able to say, please don't prosecute us. It's not really fair. Just go after the individual. We've done everything we can. And there's a case in the US, last very famous one is the Peterson case, where they went after Mr. Peterson, but a declination was given to JP Morgan in relation to activities happening in China. Similar principle should be applied here. Next is kind of risk assessments. I've sort of dealt with that already. You really need to be carrying out those risk assessments in any event, particularly if you're a financial services firm. It's not really anything particularly difficult, but it's just identifying which jurisdictions you're in, what product lines you're involved with, where the risk of fraud is, who the potential people are to do it. And that once you've got that risk assessment in place, the next bit is really, putting it into practice with your policies and procedures, and then monitoring, ongoing monitoring. I think that is something which companies should be doing in any event, and the old line is kind of audit, and frankly there is a lot of truth in relation to that, because obviously the more you review your policies, your procedures, your compliance with these things, and then are able to change them, finesse them, make them better, puts you in the best position, be that in relation to the senior manager offence, or be that in relation to the failure to prevent fraud. So those are all things which can be started, some of which, better to start after the guidance has come out, but most of them actually could be started now by companies. So I think those are, important steps that could be taken and can be looked at now. And I think that has taken me to 1 minute over the hour. So we're drawing towards the end. So I will stop there and then see if there's any additional questions from the audience, from Gaynor, or from anybody else.
Thank you, Patrick. Crikey, what a lot of information there was there, and some terrifying stuff as well. So thank you. Very important question from me. Is it possible to get your slides? Is it okay to send those around, Patrick? Or
Yeah, no, we can certainly do so.
Brilliant. Yeah, there's a lot of information there, so I think that would be really helpful.
Yeah, no,
Certainly
we're just, yeah, this is really just a lightning tour of it, just to identify the kind of, problem areas. But for me, the kind of big important one is the senior manager regime, because it simply is not getting enough press. And as Shamim mentioned, this is drawing a lot of massive regulatory obligations, but now in fact making them have criminal consequences, which is what we've seen with the NatWest money laundering case and Credit Suisse. Credit Suisse were proceeded against regulatory, NatWest were proceeded against on a criminal side of things for failure to have adequate systems and controls. So there's a real push by the FCA to go after criminal things, and now the government has seen that and seen it's a quick win. So they're potentially going after businesses as being the easy people to, because they've got deep pockets. So I think you really need to be on top of your senior managers, and ultimately it's an offence where you can only go down on bended knee and say, what else could we have done? Please don't prosecute us, and hope that you don't get prosecuted. So that for me, that's the big kind of takeaway. The other one, failure to prevent, there's a bit more time because it's not enforced yet.
Yeah, understood.
Okay, so anything else from anybody else?
Brilliant. Thank you, Patrick. I really appreciate you taking the time to give us all of that information. Like, super helpful, especially for those of us in corporates and organizations that could be caught. So yeah, really appreciate your time.
No, delighted, anytime. And if anybody does have any follow-up questions, my email is publicly available everywhere. So feel free to drop me a line, or if somebody wants to send them through to Sandra or BACFI, again, happy to respond that way, and happy to discuss it.
Brilliant. And I see it's on your last page of your slides as well. So if we circulate those, we'll be able to.
It is. This is me when I was looking slightly thinner and younger. But there we go.
You still look thin and young.
You liar. But anyway, let's crack on.
Brilliant. Thanks again. Have a great evening.
Thanks all. Bye-bye.
Thank you. Bye. Bye.